You're listening to 4CRB's interviews and talkback series.
Welcome to the studio, welcome to the microphone, Supreme Court Judge David Ashton Lewis.
Oh, thank you very much for welcoming me. I'm in a bit of a obstreperous mood this morning, so I'm depending on you and your level-headed sensibleness to keep me on the level.
Well, we asked for questions over the last couple of weeks,
Yes.
or topics that we might be able to tackle. We're going to put, we've got a few in the email and...
Can I say something before we start? I want to thank the listener because the amount of effort, and I know it may not sound much, but Colin and I go through every week to find topics that will not bore you, will not turn you away, and you're a loyal listening group because you don't seem to be turned away. So when we announced a couple of weeks ago, would you please send in, I'm very pleased to say that people have done that.
Well, look, if you do have some topics, mail at 4crb.com is the email address to email them into, and we can put them in the pile to consider. But today we've got two questions, and we thought we'd put them together because they're in the same genre.
Yes.
First question...
Well, that's a big word, Colin.
Well, here we go. Obstreperous is over on the other side of the table.
Please go on.
Okay, so the first one was from Margaret, and it was the two standards in the legal system. The difference between the criminal standard, which is that on the balance, not the balance of probabilities,
Beyond reasonable
doubt. And then you have the civil court that is on the balance of probabilities.
Yes.
Why the two different measuring sticks?
Okay. There were probably up to about the beginning of the 20th century, there were 27 crimes for which the death penalty carried. So horse and cattle stealing, death. Rape, of course, death. Murder, death. Manslaughter, death. Robbery, death. Forgery and uttering, death. And so it went on. There were 27 of them. Now, the whole idea, which came long before the 20th century, was where you have a penalty that is the loss of your life, that amount which needs to be satisfied and proven, if you like, has to be strict. And that's why I developed the sense of beyond reasonable doubt. So proof has to be not beyond any doubt, but beyond a reasonable doubt. And that is, if in all the circumstances there is a feeling of guilt, is it reasonable to find that guilt? If the answer is yes, it's not good enough. You had to be satisfied beyond reasonable doubt. So people would always ask judges, well, how do I have to be satisfied beyond reasonable doubt? Well, that was the judge would encourage the jury, look at the evidence, listen to what the barristers have submitted, and if you find you've heard all that and you're still satisfied beyond any doubt and then any reasonable doubt, you should return a verdict of guilty. Now, that was fair and that was appropriate. It's always been difficult, but because of the penalty involved, either loss of life or substantial loss of freedom, for 20, 30 years in prison, that was seen as an appropriate standard for 12 men and women to get to a point of saying, well, I might have a doubt, but in these circumstances, that doubt is not reasonable. Therefore, I can be satisfied beyond reasonable doubt. Now, with the civil standard, that is, on the balance of probabilities, because the civil standard involved, I've defeated you in a contract claim. So, Colin, you've got to pay me $100,000 or $1 million or whatever it is, because the court has found that you have broken a contract. You have breached a relationship between us. It's not a criminal breach, but it's a breach. You signed a contract and you've now jumped out of it. The standard was, well, okay, on the balance of probabilities, did Colin Bolevsky do that? Did he breach what he undertook to do, not beyond reasonable doubt because it's not criminal, but on the balance of probability? So was it probable that, one, there was a contract, two, that Colin breached it? Now, if the finding on the evidence is yes, Colin did breach it, so therefore it is probably correct that David suffered massive loss. Therefore, Colin now must compensate for that.
That's very interesting, mate, that you go back all the way back to capital crime.
Yes.
Where the chance of if you were guilty, you lost your life.
You lost your life.
Hence, that balance of whether you did it or you didn't has to be a lot more stringent than whether it is probable or improbable that you did it.
Now, it's important to remember that criminal courts, you hear this all the time from people, criminal courts don't find people innocent. They find that they are satisfied that Colin Bolevsky did this beyond any reasonable doubt.
Or he didn't.
Well, if they can't find beyond reasonable doubt,
guilty or not guilty,
he's acquitted.
Yes.
He's not guilty. So it's very important to remember for the listener out there, criminal courts don't find offenders innocent. Because I remember addressing, it may be that my client did do this, and you have to be careful saying that. It may be that Mr. Bolevsky is my client and he did set fire to the barn and kill animals, but you've got to be satisfied beyond reasonable doubt that he did.
Indeed.
And that always caused difficulties.
All right, I've got another one. Hopefully that answers your question,
I hope it
Margaret.
does,
I
and
think
if not,
it's an interesting balance, and it makes a lot more sense now when you go back into the history of the legal system and understand where it all came from.
Yeah,
I think that's so, very, very important indeed. Now, forgive me, I haven't got my glasses, and the email I do have in front of me is very, very small writing.
Glasses. I don't wear glasses.
So this is
I'm not as old as Colin, ladies and gentlemen. He is a pensioner.
Yes, look at that. Yes, he's. Well, Ian.
No, in fact, I was 19 when he was born.
Oh, stop it.
Oh, stop.
Okay,
right,
so Ian joined us at the afternoon tea last week or the week before, and he is a retired detective in the New Zealand police force. Spent
very
21
good
years
police
there.
force. Yep.
And he was brought up to respect the rule of law, and during his service, the judicial system as part of his life. Now, he has always been impressed with the judiciary in both New Zealand and Australia, in that there is no political interference from the government in running of the courts. Now, I know you'll have something to say on that,
I will.
but I'll finish the email. I'm deeply concerned that in the United States that it appears to be a situation where judges are admitted to the High Court because of their political persuasion.
Yes.
I believe and will always believe that there is no place in the administration of the law with political interference. The law is the law, and rulings should be on fact and evidence.
Yes.
Okay, not on how you are swayed by political masters. I am sure listeners would love to hear more on this. David.
Okay, well, Ian, thank you very much, but I can see you're retired and you belong to one of the world's best police forces, those damn Kiwis. And everything they did was good, and Australia as well. But everything you've said is correct. Sadly, that has begun to change. And our American cousins started this cancer by looking to appoint people who held certain political positions, either, in their case, Democrat or Republican. Now, I have seen it in the last 10 years in Australia start to leak in. I have a colleague who is probably a top, well, not probably, is a top barrister in New Zealand. She was, and she's 58, and she is the equivalent, she's never sought it, of King's Counsel. She was involved with me in a matter. I was on the bench, she was, and she sought leave to adjourn a matter in the High Court of New Zealand because she was required in another country's Supreme Court. Now, when we were young, and I was young, judges would take note of that, and provided the Supreme Court in the other jurisdiction was considered to be equivalent, then they would grant the adjournment. Now, in this case, the High Court did not, and she was unable to do the job that she'd be retained to do. The Law Society then asked her to show cause why she should not have her practicing certificate removed from her because of she didn't turn up to a Law Society function and that involved trust accounts and everything. She told the Law Society because I was involved in a 5-day trial in the High Court in the country, New Zealand. They totally ignored that and punished her. I couldn't believe it when I saw this, but I'm sad to say, Ian, I'm sad to say our courts are becoming politically dominated. So if you've got a Labor government and they want to appoint a judge, or a Liberal government and they want to appoint a judge, they now do look for a clearly Liberal or Labor judicial officer. That is a disgrace, and it is a breach of the concept under the rules of parliamentary democracy of the independence of the judiciary. I have made rulings against the party that appointed me, and I have made rulings against that party. 30-odd years ago, the government accepted it. Now today, in recent era, I have been vilified, I have been attacked as biased, and by the Law Society of that and other judges. So sadly, I think we are going, in many ways, in the direction of political appointments, and you hold a political line. I heard today, driving down here, that a young man who had been sentenced only last couple of years to 14 years jail, no early release, no parole, because he was 17 and he had murdered and killed a woman. A man lost his wife and mother to young children. He then appealed against that. The appeal court held, yes, he was 17 and he was young and didn't know, and they reduced that penalty substantially. Now, fortunately, the Director of Public Prosecutions appealed to the High Court of Australia. Now, here's an example. Those judges on a state appeal court are equally the equivalent of judges on the High Court. That is the High Court of Australia. And the High Court of Australia unanimously said the appeal court got it wrong, and he should never have been reduced, and they reinstated the full sentence. And this is happening time and time again. I was involved, well, most people will remember that the Catholic Archbishop, Cardinal Pell, and he was found guilty of gross and indecent behaviour with a young man. It went to the Victorian Court of Appeal because he was sentenced to a lengthy period of imprisonment, lost his career, lost his standing, and the Victorian Court of Appeal, 2-1, because there are 3 judges on it, upheld that the Victorian court was correct. Now, the one judge who said no, the Victorian Court of Appeal was wrong, was the only judge on that court who had a lengthy judicial experience. The other two were political appointments who towed a party line, and we all know about gender selection and everything. And so, luckily, he appealed that to the High Court. The High Court unanimously in Canberra said those two judges on the Victorian Court of Appeal got it absolutely wrong, and the judge who had lengthy experience as a barrister in criminal law, whatever, got it right. So the acquittal of Pell was upheld, and he was acquitted on the basis that it was manifestly impossible for him to have done what the accusers said was done. Now, here's the point again. So what were the police investigators doing when they looked at it? Look, police investigators, particularly in the violent crime area, are not dills. And they would have looked at this and said, no, look, he simply couldn't have done it. But did they? No. They filed an indictment, and that cardinal had to face his day in court, where if he'd been investigated either by properly trained police investigators or non-political, and this man was absolutely, it was a bit like Lindy Chamberlain. There was either those who believed that she was innocent and those who believed that she didn't. Now, this points out, and I'm nearly finished, why the pub test and the public have no place in these things, and they should just be dismissed, because it's the police who gather the evidence, put that evidence before the Director of Public Prosecutions, who's the one who makes the decision, no, there's not enough evidence here to satisfy a jury beyond reasonable doubt, or, no, it should go to a jury. But what we've got now, everyone's an expert, everyone has a say, and I'm really glad that my judicial career is ending and I will be retiring in December, because I'm aware of what the complaints are. If Judge Wall is listening to this, he would have experienced this, and all I'm saying is that unless we have a really good think, we're just going to go down the path of the United States. Political appointments to the bench and the high bench, and they will follow a political line.
Look, I do remember you telling me at one stage, David, that you didn't have to have in the past, a political career to become a judge.
No,
in fact,
that counted against you.
That counted against you. Well, that's an interesting component. So you mentioned to me that if you were a fine, upstanding member of the community, your community could appoint you.
No, not in Australia.
No.
That's in the United States, but only in state courts. It's not in the US Supreme Court. It's the same process as our state Supreme Court judges, who are appointed by the political party in government at the day. Now pick up that. If you've got a Labor government in and there's a vacancy, naturally they will favour Labor appointment. You know, top barristers who are known as favouring the Labor Party. That just has to stop.
And look, we all remember the Joh Bjelke-Petersen days, and the thing that brought down those guys at the time. I think there was I've forgotten their name of the judge who was favoured, and they didn't get the judge on the issue that they wanted resolved.
They got
or
him
quashed.
Yeah. Now, remember Lionel Murphy. Lionel Murphy was appointed to the High Court of Australia by the Whitlam government. Now, whether you liked, he was a top Labor union, probably socialist communist defender. And he did it because he was a brilliant lawyer, brilliant barrister, QC, and he was appointed for those reasons to act. Anyway, a vacancy came onto the High Court of Australia. He was appointed. Now, if anyone who's trained in law reads his judgments over, I think, 3 years, his judgments are excellent. They do not display any left or right bias. But look what happened. The enemy's got, he was at a function with the Chief Magistrate in Sydney and made a statement to him. Now, I think his name was Maury Farquhar, who was then the Chief Magistrate, and Lionel said, "What about my little mate?" And it was a union fellow who was about to become before that judge for a committal hearing. Well, the Conservative side of politics picked that up, hounded him, and he was forced to retire. Now, I'm no Labor man, but I have voted Labor in my life, and I certainly supported him for his brilliance in jurisprudence. But political persuasions destroyed him. And it's so sad. Now, you can never keep politics out of anything. It's always, but there should be a very clear statement to both left of centre, right of centre. You will appoint, when you're in government, different people with mainly left of centre views. That's fine. But the moment we start to lose confidence that they are anything other than neutral and decide on the basis of the evidence and the law, we will bring that career to an end. Now, that used to be the way. It isn't anymore.
Well, David, they were two fantastic questions that we got from our little...
Did I answer them?
You answered them very well.
Oh, well, I hope
the
so.
listeners will be the judges to whether you were... you explained them in the pub language.
Did I? Well, ladies and gentlemen of the listening jury, please don't crucify me.
No.
I hope I've answered.
It was a great point to make that some of these laws were rooted or formed when we had capital punishment. I thought that was an interesting point of view because, yes, absolutely, if I'm going to lose my life, I want you to be damn sure that I did it.
Absolutely. And I repeat again, I am the product of 5 grandparents ago of one in the family, one who was a convict. And she had stolen...
That explains a great many things now, David.
Oh, well, I hope you won't judge me too harshly. I have one convict in my family, and naturally, she is Irish. And she had stolen a pair of kid gloves, a candle holder, and 2 doilies. She was put before the Old Bailey in 1796 and sentenced to death. She was 17 years old, but she had the option. She could choose either the gallows or being transported for life, and she was 17, to New South Wales, because all of Australia was New South Wales then. So she arrived in Sydney town, I think, in about 1798. And she worked in service, as most women convicts did. And she met my 5 greats-grandfather, who was a free settler. And they at church. Now, they obviously became fond of each other. And he asked her to marry him. She said yes, but he had to get permission from the governor of New South Wales to marry her because he was a free man, she was a convict.
Wow.
And naturally the governor granted it because they needed children in the new colony of Sydney Town. Well, the town was Sydney Town. So they got married in 1799. And guess what, Colin? The bane of your life, me, is here today because of that.
That explains the little bit of scallywag we have.
I like that word, scallywag.
All right, David Ashton Lewis, thank you very much for your time this morning.
Thank you for having me, and I hope that has helped. Please, ladies and gentlemen, please keep sending in questions. We will still think of topics, but please help Colin and I sending in questions because Ian and
Margaret,
thank you.
You've been listening to 4CRB's interviews and talkback series. Support local online content and become a financial supporter today at 4CRB.com.